Well, good morning, everyone, and welcome to this morning's webinar. I'm George Spees with the Pennsylvania Office of Open Records, and this morning we're going to be talking about the right to know law and as it relates to payment issues. This is probably one of my favorite webinars because there's a lot of misunderstanding about the payment side of the right to know law. A lot of people assume it's free and it's not. So whether you are a requester or whether you are an agency open records officer or someone who's working with the right to know law, hopefully you'll find this to be a helpful session. A couple preliminaries. First, if you've never participated in one of these webinars before, it is essentially a PowerPoint presentation with me talking in the background. All of the PowerPoints, including this one, are available on the OOR's website underneath the training tab. And you're welcome to use those for either future reference. Perhaps you have a colleague who wasn't able to attend this morning. They can refer to that. Or if you're conducting your own localized training, feel free to use any of our products to help you out. This session is also being recorded. And within a couple days, usually what happens is the admin staff will download it and put it on our YouTube channel and then link it to the website. So within a few days, you should be able to go to our website and find the actual video of this session. I qualify that a little bit because there have been some technical difficulties lately with bandwidth where the Commonwealth of Pennsylvania is limiting how much each account can post. And I understand that there were some problems recently that some of the videos they weren't able to upload. I'm not sure what the status of that is right now, but keep an eye out for it if you're curious about listening to the recording. As far as questions go, use the chat feature during our session if you have any questions, and I will do my best to answer as we're going through. But I have two requests. First is, we're talking about the right to know law and payment issues, so let's stay on topic. And the second, and probably more important one, is that the shorter, more concise you can keep your questions, the better. And I say that because with all the people participating here, it's somewhat awkward for me to sit here and read through several paragraphs of a question while everyone else is waiting patiently. Look, if you have something that is particularly complex, or maybe just unique to your situation, we'll do one of two things. We'll wait until the end of the presentation and I'll come back to it and do my best to answer it for the good of the order for everyone who can hang around, or we'll take the conversation offline. The contact information for our office is on the screen right now, and our admin staff is very proficient in being able to address most of the questions. And if you give us something that stumps them, well, they'll escalate it up to one of our senior managers. And typically they get back to you within a day because we figure, okay, you've got a question. It's probably time sensitive and it's probably important. So they're usually pretty good about that. So, regardless of the circumstances, feel free to reach out to our office if you do encounter a problem or if you have some questions. We're more than happy to help you out. And then finally, let me apologize for sounding like a frog. For some reason, I've been wrestling with a stuffy nose for the last week and a half or so. It sounds a lot worse than it is, but every now and then I have to cough or whatever, and I just apologize for that. It's just part of getting old, I guess. But anyway, let's focus on the presentation. I think that takes care of all the preliminaries. So yeah, let's dive into the topic now. Okay. The payment side of the right to know law is actually, you can find it in the law itself. And if you never looked at the law, you can download it from the OOR's website. It's not a long law, and for the most part, it's written in English. But you'll find a reference to it in section 1307, which authorizes the Office of Open Records to establish a fee schedule. And like the fee schedule itself is also posted on the website. And it's reviewed biannually, every 2 years. And prior to doing that, we use social media and other resources to let everybody know that this is coming up. And if you have any comments or concerns, please reach out. And I can say from my own personal experience that this has happened in the past. And usually at every cycle, we adjust some of the costs, accommodate for some new technology and the like. I've seen some of the fees go up. I've seen some of the fees go down. So, your comments do matter. And we do listen to you. We talk about it and figure out, okay, does this make sense? And like I said, I have seen the results of your comments. In a nutshell, it's for hard copies of public records, it's 25 cents a page, single-sided black and white, 8.5 by 11 or 8.5 by 14. If by chance color copies are requested, you can charge up to 50 cents a page, single-sided, color, 8.5 by 11, 8.5 by 14. Now, all other sizes are actual costs, and this is covered a little bit further in the presentation, but occasionally folks will have a large scale copier, and depending on whether they own the copier or they're leasing it, their contract may account for a fixed cost for large scale copiers. If you can document what that cost is, whether you do it in-house or need to go outside of your organization to generate that large-scale copy, you can charge the actual cost, whatever you're being charged for it. Now, if you get a big request that requires a big response, in excess of 1,000 pages, the cost per page, the maximum, drops down to 20 cents once you get above 1,000 for black and white. Actually, that provision was the result of some public comments that we got last time we revised the fee schedule. And then I want to emphasize with the fee schedule, you've got the schedule itself, and then down at the bottom in fine print, there are probably about a dozen footnotes. Those footnotes are enlightening because throughout the life of the right to know law, going on, 13 years now, there is case law that has focused on disputes over what can and cannot be charged. And a lot of those footnotes focus on exceptions or the rationale behind why certain charges exist and what you can and cannot be charged for. So it's usually helpful to take a look at those footnotes to get a full understanding of what the fee schedule actually represents, okay? Moving on, I did mention pass-through costs, okay? What can an agency charge you for actual or what we call pass-through costs? And this is where, it can actually be documented that above and beyond the fee schedule, producing this copy of a record cost us X amount of dollars. Therefore, we're going to pass that cost on to you. The most common one is postage. Let's say that someone submits a right to know request for hard copies, and the arrangement is such that they want those hard copies mailed to them. Okay, so the agency generates the copies, they charge up to 25 cents a page, and then they take the package, the envelope or whatever, and put it on their postage meter. And the postage meter determines that in order to mail this package to this address, it's going to cost, let's just say $3.15. That $3.15 is a documented pass-through cost that can then be added on to the invoice. Okay, so in addition to whatever you're charging for the actual copies, you can add the cost of postage onto that. Outside copying fees for blueprints. Let's say you don't have, or an agency doesn't have a large-scale copier, and someone requests a copy of a print, and it's determined that the print is a public record. Well, the agency can go down to Staples or Kinko's or maybe the local architecture firm, and they're going to charge, let's just say $12 a sheet Okay. Well, that $12 is a documented cost placed on the agency in response to the request. So the agency can then pass that on to the requester because it's a documented cost in addition to whatever the fee schedule would allow. Okay, so that can be passed on. You see how all this works. The next one, analog recordings. Yeah, I'm not even going to focus on that. I should probably take this out of the presentation because we just don't see requests for cassette tapes that much anymore. Storage media, such as flash drives, we do still see that. Now, I'm going to talk about that. As a matter of fact, I'm going to go to the next slide here because of a best practice that we recommend. It used to be that many agencies, in response to requests for electronic records, where that response was so big that it would exceed their email capabilities, um, they would keep a supply of flash drives for large responsive requests. That has kind of changed, and I just want to tell you what's going on. Um, and it also dealt with security concerns, because um, sometimes people would come in with their own flash drives and they'd say, I'd like a copy of these electronic records, just load them on my own flash drive. And the security people, the IT folks, would throw a wobbly over that because, there could be a virus or malware on that flash drive. We can't accept that. Okay. So now what's happening is when an agency receives a large request, and this does happen. For instance, right-of-way projects related to traffic changes and so forth. You've got environmental impact statements. You've got all kinds of documents that usually exceed the email limits. Okay, but back to where I was headed here. Um, what agencies are doing is they're saying, okay, your request is approved. In order for us to transmit it, send us an unopened flash drive, brand new, and we will provide you with the records. And then what they do is when that flash drive arrives, they usually segregate the electronic records, move them over to a standalone laptop that is unhooked from their network. So then, if just by chance there would be a virus on the flash drive, and usually there isn't if it's unopened, um, the security software on the laptop catches it, and there's no chance of it going into the network because the laptop has been unhooked. Okay. So that seems to satisfy everybody, and it seems to be a process that works out fairly well. It's what we do here at the Office of Open Records. Um, I've even seen flash drives now that have a manual code that you need to plug in order to open the flash drive. And then we received one time that had an electronic code. They sent us the flash drive, and then they emailed us the electronic code to access the flash drive. So things are, getting pretty technologically savvy when it comes to security issues. But this is what we recommend as a best practice. Now, there's nothing in the right to know law that says this is what you must do when it comes to transmitting records using a flash drive, but we're just putting it out there that this is what many agencies do, and it seems to be working out for them. Maybe you want to consider it rather than have a flash drive or a supply of flash drives available, and then you end up having to charge those pass-through costs, and you've got to wait for the invoice to go out. You've got to wait for the payment to come back, the payment to clear, and then you mail out the flash drive. This just seems to make life easier. So something to consider. Okay, moving on. Let's talk about what you cannot charge under the right to know law. First, there's no charge for labor, and that's whether it would be like an hourly rate or a fixed fee. There have been proposals to amend the right to know law in the past. Those proposals have even had successful votes in one of the two houses of the legislature, but they've never gained enough traction to make it into law. Okay, so as of now, an agency cannot assess a labor fee in responding to a right to know request. You cannot charge for any sort of legal review, whether it be an in-house solicitor or some form of outside counsel. You can't assess like a processing fee. And occasionally we still see those. We periodically will go out and review agency websites to see if they're in compliance with the right to know law. And every so often we run across an agency that says, okay, for every right to know response, we're going to charge you $10. Okay, you can't do that. That's not consistent with the right to know law or the fee schedule. You can't charge a redaction fee. A redaction is where you've determined that a record is public, but there's some sensitive piece of data, so we're going to black that out. Okay, so since we have to black it out, we're going to charge you an additional $10. No, you cannot do that. You can't charge a scanning fee. And this, I haven't seen this come up in recent years, but I used to get it frequently where someone would email us or they would call the office and say, hey, uh, I'm scanning these records in response to a right to know request. And why can't I charge for scanning? Because I'm going through the same physical exercise as if I were making copies, same wear and tear on our copier, et cetera, et cetera. Um, the thing is, you cannot charge for electronic records. And when you scan, that's what you're doing. You're creating electronic records. And sit tight because as we get into the presentation, I think there's a good chance that you don't have to scan in the first place. Okay. Common misunderstanding, and I'll explain it when we get to that section of the law, that section of the presentation. No, you cannot charge for the electricity that it takes to generate the copies. Yes, the question has come up, and my first response back to them is, how are you going to calculate the cost of the electricity? But no. And then, like I said, you cannot charge for electronic records. These would be your emails, Word documents, Excel spreadsheets, various database files, and the like. Now, if there is a dispute over what an agency is charging a requester, the requester can file an appeal based on that dispute over the fees. And if you're curious about this, you can go on our website. We have what's known as the Final Determinations Database, which is every decision that the Office of Open Records has ever issued since 2010 is in this database. It's over 30,000 decisions. And it's searchable. And there's one field where you can simply put in a text string. So you could type in the word fees, and every decision involving a dispute over fees will come up, and you can kind of read through them and get an understanding of how the Office of Open Records has responded to various disputes over fees. But the bottom line is that if a requester believes that an agency is inappropriately charging them for something, they can file an appeal, and we will look into it and render a decision on how that dispute should be pursued. Okay. Now, this is what I'm talking about when it comes to scanning. This is an important section of the law. This may prove to be the most helpful slide that you see here this morning. But essentially, I'm referring to Section 701 and the reference to the word medium. Now, I'm going to paraphrase here, but essentially what it says is that an agency is only required to provide the record in the medium in which it exists. Okay, and what that's referring to is hard copy versus electronic. So if someone submits a right to know request, and let's say they send it by email, and they say, I'd like these public records, and I'd like them sent to me electronically because it's easy and electronic records are free. Okay. Well, if the agency does not have the records in electronic medium, let's say they only have them in hard copy, the agency is not required to provide them electronically, okay, because that would involve changing the medium. So the agency does not have to scan the records in because of changing that medium. Okay, let me repeat that. The agency does not have to scan the records in because that is changing from hard copy medium to electronic medium, and they're not required to do that. The response would be something to the effect, yes, we have these records. However, they're only available in hard copy. We'll be more than happy to make copies for you, but then we charge you up to 25 cents a page. Now, many agencies are just finding it easier to go ahead and scan. Okay, it's really your decision. Here at the Office of Open Records, most of our records are already scanned in, so we have them electronically, so it's real easy to send them out. But if by chance someone should request a hard copy only record, the way we grant the request and transmit it, we usually just scan it in because it's just easier. It takes a lot less time. And at the end of the day, when you look at man hours, it's just cheaper for us to scan them in and send them out. So that's usually what we end up doing. But Section 701 of the law does, um, does clarify that an agency does not have to scan in otherwise hard copy only records. If you do have it available electronically, then you have to provide it electronically. If you have it in both, you have an electronic copy. So if they request electronic, that's how they get it. Now, medium versus format. Okay, format refers to the software used to generate an electronic record. Okay, and I have in here the Excel issue. Let me explain what this is all about. Um, Several years ago, there was a concern with many agencies about requests for Excel spreadsheets. And their concern was that, well, if we send out the spreadsheet, the requester will be able to manipulate the formulas that control what shows up in each cell of the spreadsheet and could possibly misrepresent what was sent to them. Now, I am not aware of this ever actually happening. Okay. And that would be an issue outside of the right to know law. But it did go far enough that we have case law that controls this issue. However, that case law is evolving. Now, where it started was the court said um, if an agency wants to, they can provide the spreadsheet as a PDF file where the cells cannot be manipulated because the purpose of the right to know law is to provide copies, and a PDF is a copy, even though it doesn't contain the formulas. Now, where we're at, after several years and a number of different cases, is that if a requester specifically says, I want the Excel version, the agency must provide that. If they don't specifically say Excel, they just say, I want a copy of the spreadsheet. If the agency wants to, they can make a PDF version and send it to them. Okay, that's where we're at now. I haven't seen any new case law for a couple years on this, but that, I'll just leave it at that. That's where the law stands right now. I haven't really seen this be a front burner issue for several years, but every so often the question comes up. Then we get into the issue of proprietary formats. And this is where you've got a semi-custom software program that is not commonly used among the public. Typically, you'll find this with police departments and some school districts. At issue is the fact that there are reports that can only be generated and read if you have a copy of the proprietary software. Pardon me. So there's no utility that would allow them to generate an ASCII file or a CSV or something like that so that they could send it out to a requester. If this is the case, if the agency has proprietary software that does not allow them to generate a record that can be read if you don't have the software, then they are not required to take any steps to see that that happens. Okay. The proprietary software basically gets them a pass. Again, I haven't seen this come up in recent years. It seems most departments are now using software that allows them to generate publicly accessible files. So, but still, they are out there, and occasionally this question comes up. Okay, let me get a sip of coffee. Switch slides, and we're going to talk about redaction costs. Now, like I said before, redaction is where you've determined, okay, this is a public record, but there's some sensitive piece of data on that public record that we can't let go out the door. It could be a social security number, a home phone number, personal email address, or the like. So we have to redact that. Typically, there's two ways to do this. The first and most common is electronic. This is where, uh, like for instance, the Adobe Office suite has what's called the redaction tool, where you can bring up the electronic record and electronically and securely basically eliminate that sensitive piece of data and then send it on its way electronically in response to the right to know request. The second is a manual redaction. It's an electronic record, but it's got that sensitive piece of data. So you print it out, and then you take your whiteout or a Sharpie, and use whiteout because that's more opaque than a Sharpie. And you blank out the sensitive piece of data, and then you scan that record back in. Well, because you generated that hard copy, you can now charge for that. Okay, so that you can, in a roundabout way, assess a fee for redaction costs because the requester has to pay for that piece of paper. Okay. Now, where we stand at now with case law, actually, it's not case law. It's I think it's based on our final determinations, which do carry the weight of law. But where that stands is that the policy of our office is that if you have redaction software, you should use it. We're not saying you shall use it, and it may be headed in that direction, but as of now, the term is should. Okay, so we're not saying you like absolutely have to use it. We're just saying, look, this is the way to go. I guess what I want to say here, and we'll get to this sooner or later, so we might as well do it sooner, is that the majority of right to know requests are submitted for legitimate reasons. And people are willing to pay a nominal fee for those legitimate requests. Okay, it's simply the cost of doing business with your government. But our office also acknowledges that there are a handful of people out there who have weaponized the right to know law. And for whatever reason, the relationship between them and the agency has broken down. And they've decided they're going to be a pain in the neck. And one of the ways they're a pain in the neck is they file a lot of frivolous right to know requests. And if they're savvy about it, they do it for electronic records and there's no fee. So, you have to, the agency has to grin and bear it. Well, what if some of those electronic records had sensitive pieces of data and you had to do a manual redaction? Okay, yeah, it may be a nominal fee, but my experience is that while legitimate requesters are willing to pay a nominal fee for the records, most problem requesters are not. And if you can come up with a way of assessing costs, then that person's going to go away. They're not going to bother you with right to know requests anymore. Okay, so if you're from the agency side, this is a potential solution for dealing with problem requesters. If you're here today and you're a requester and you happen to be a problem requester, well, shame on you. Stop doing that. Okay. But this is just one consideration when it comes to dealing with folks that are using the right to know law for the wrong reasons. Okay, back to redactions. Oh, let me talk about inspection requests. One of the facets of the right to know law that a lot of people may not realize is that in addition to requesting copies, you can request to inspect the original records. Okay. If someone requests to inspect the original records and there's that sensitive piece of data, the agency again can generate a copy, blank out that sensitive piece of data, and charge the requester, even though they're coming in to inspect the record. It's just that if they decide to pay, when they leave, you should give them that copy because, they did pay for it. Okay. Then the final point is that a redaction is basically a denial. So even though you think you're granting the request by letting them look at the redacted record or giving them a copy, if they disagree with what's being redacted, they can file an appeal. And yes, you can go into our database and search on redacted records and see all of our decisions related to that. I think about 4 or 5 years ago, the whole medical marijuana issue with the Department of Health, it entirely focused on whether or not the redactions were appropriate. And the courts got into this, and you can get an idea as to how the courts have ruled. But if number one, when you grant the request, you should indicate, the agency should indicate that there is redacted information, but you tell them what's behind the redaction. There's a social security number, there's a home phone number, okay? So that the person understands why that portion of the record is being denied. And then they can decide for themselves if they want to pursue an appeal. Okay, so a redaction does represent a denial. Okay, question has popped up. All our records are only in electronic format. How do we allow people to come in and inspect? Okay, that is a great question. I should have addressed that. Under the right to know law, you will find a provision that basically says you are not obligated in any way to allow a requester to access your computer system. So essentially, you deny the request to inspect based on that provision of the law. Off the top of my head, I don't have the citation as to what section that is, but if you take a look at the law, it's in there, okay? And so you do not have to give any requester access to your computer system to view electronic records. And believe me, that those sorts of requests do come in, particularly occasionally with problem requesters. Okay, good question. Thanks for that one. Okay, let's move on to the next slide. Charging fees. Well, the right to know law doesn't get into the actual process. Rather, it just, and again, I'm paraphrasing, it says records are provided upon payment. So that means that the person pays first, then they get to see the records or they get the copies of the records. Okay. So let's run through this process, because the other thing that I want to emphasize is that within the right to know law, there's these hard deadlines that I talk about in the basics webinar. Those deadlines are for the responses. They're not for the actual provision of the records. Okay, if you read through the law does not say you must provide the records within a specific time frame. Rather, it says you must provide the response within a specific time frame. So you get a right to know request. The agency gets a right to know request. The first deadline is they have 5 business days in which to generate an initial response. Okay. Now let's say that that response is we're granting your request and we're going to provide you with these records. And then they add to it, however, first you have to pay us for the copies we're going to generate. So it's going to cost you, I don't know, $30. Send us a check And when the check clears, we will send you or provide you with the granted records, the responsive records. Okay. And it's very subjective, but it's what's a reasonable period of time? Well, you would wait for the check to arrive, give it a couple days to clear. You get, a confirmation from the bank that the check is cleared. And then within a couple days, okay, you would mail out or in one way or another provide the responsive records, okay? And that's pretty much how that would be viewed. It's never been litigated as to what is a reasonable period of time for sending out the actual records. If the person doesn't see anything after 30 days, they can take legal action and appeal it, or, well, they can't appeal it, but let's say that our office ordered the release of the records, and oh gosh, I don't want to get in that. I'm going down a rabbit trail here, but it's never been litigated as to what represents a reasonable period of time. But from our perspective, it's usually a couple of days. Okay. Then getting back to the slide, we've got this provision in here in section 1307 where what if it's a really big request and it appears that it's going to exceed $100? Under the right to know law, the agency can demand full payment before they begin processing that big response. Okay, you get the request, you say, oh, wow, look at this. It's going to be a couple $100. Maybe it's one of those environmental impact studies. So you can contact the requester, say, since this is exceeding $100, we're going to charge you for the full amount. Send us payment before we begin processing. And then you settle up on the exact amount when it comes time for the actual provision of the records. I like to view it as a security deposit. The right to know law doesn't want agencies getting stiffed for generating big responses and then there's no payment forthcoming. Okay, so this provision of the law allows that uh, to take place. So you would then wait for the payment, process it, and then make arrangements for the actual provision of the records and settling up on the exact cost. Okay, so the law does allow that to transpire. And then I don't want to get into it too much, but there's this, because it just doesn't come up that often, but there's this provision under Section 905 for record discard. Let's say you get a request, the agency generates the response and all arrangements are made, but then the person is a no-show or they never provide payment. Okay, well, first offhand, the right to know law allows the agency to hold on to everything for 60 calendar days, 2 months. If the person hasn't shown up or provided payment, if you haven't demanded payment ahead of time, after 60 days, the agency can discard all of those records. Okay, you can recycle, shred them, do whatever you do. Okay, however, because the agency did everything it was legally required to do, the debt does not go away. Okay, that's outstanding. And there's no statute of limitations. It doesn't go away after a month. It doesn't go away after a year. It doesn't go away after 5 years. If that debt is still out there for an unpaid right to know response, the agency is no longer obligated to process any further right to know requests from that same requester. Okay. The agency can deny any subsequent requests if there is an outstanding balance that that person still owes the agency. And again, going back to problem requesters, if you can assess a fee and that person balks at paying the fee, then they're going to go away because you no longer have to process right to know responses from that, or I'm sorry, right to know requests from that problem requester. But let me make it perfectly clear though, if that's what you're doing, the agency needs to make sure that all its I's are dotted and its T's are crossed, because you are denying a subsequent right to know request, and that can be appealed. And the appeals officer in our office is going to want to see all of the documentation, you know, all the correspondence back and forth between the agency and the requester. How did the agency calculate the fees? What opportunities were given for payment and the like? Okay. Now, if you've done your homework, if the agency has done its homework, you'll find that the appeals officer in most cases is going to agree with the agency and support the denial. I mean, that's been our history here. But if it's sloppy and there are questions, then, you could run into some issues. So just, be diligent about this. All right. And then finally, there's nothing in the right to know law related to collection activities for outstanding fees. Okay. And so that's really up to each agency as to what steps they take for collecting outstanding fees for right to know responses. But the main takeaway here is that if there is an outstanding fee, the agency is no longer obligated to process any further right to know requests, whether it's for the same set of records or something entirely different for that particular requester. All right. You've kind of seen me hint about this, but let's just get it out in the open. I was the OOR's right to know officer for 8 years. And I can tell you that to make things work smoothly, you want no surprises. There's absolutely nothing in the right to know law that prevents a conversation between the agency and the requester. You receive a right to know request, and it looks like there's going to be some costs involved. Pick up the phone or send an email back to the requester saying, hey, we got this, we're granting it. It looks like it's probably going to cost around $30. Are you okay with that? Because, like I said, there's a lot of misunderstanding about the right to know law where people think it's free and it's not. Okay, you can assess fees. So, I've done this plenty of times. We're getting back to the requester. Are you willing to pay this amount before we begin actually processing the response? Because, maybe they'll say, yeah, I was kind of expecting that, so let's move ahead with it. Or they may say, whoa, wait a second. I thought this was all free. I misunderstood. No, I'm withdrawing my request. Okay. Saves everybody a lot of headache, and it could save the agency a lot of work and, subsequent headaches with attempting to collect on a response that the requester never had the intention of paying for. Requesters, when they submit a right to know request, they can say, I'm willing to pay up to $10. Anything above that, please contact me. Okay, so then you can have this discussion. All right, perfectly legitimate to put something like that on a right to know request. All right, but the main takeaway here is what I'm saying is that talking to each other is good, okay, because it can solve a lot of problems before they even begin if everyone understands what the parties want and what the parties can do. Okay, now, a couple things you need to understand here. First is that an agency cannot demand why a requester is submitting a right to know request. But the agency can ask. Okay, the person does not have to tell them why. But let's say, and let me just get into this a little bit. You have to look at this from both sides. A requester has a problem. They know that that problem can be solved with a record that the agency has. Now, they may not know the form number. They may not know, the record title, but somewhere in there is going to be the solution to their problem. So they submit a right to know request and they cast a wide net. They write it in general terms. It is specific enough, but it's still in general terms that it's going to cause the agency a lot of work. Now, the agency gets this, and their perspective is just the opposite. They want the request to be as narrow as possible so that they can go right to the file cabinet, pull out the record, and send it off and get on doing the other business that they have to do. Okay, well, the solution is usually somewhere in between, but the process is started with communication. And a savvy right to know officer will call or email the requester and say, hey, I got this request. I don't think you realize how broad it is, how much work is involved, and how much this might cost you. Do you mind telling me why you are filing this request? And maybe I can help you out. Okay. You see right here, the parties are working together. Okay. You're establishing some trust because I can help you with this. All right. So the person explains, well, I'm having this issue with the IRS with my taxes. They say I need this document from the local, from the township related to my business. I'm not sure exactly what they're talking about. So I just filed the right to know request. The right to know officer says, oh yeah, we deal with this fairly commonly. I know exactly the form that they're looking for. I'll go over to your tax file and pull it for you. I can have it ready this afternoon. Okay. Granted, this is a hypothetical conversation, but you see how it works. Okay. By the parties talking to each other and working together, the problem is solved. Less cost for the requester, a lot of less work for the agency. Okay, so communication is good. All right, a big question has popped up here. What did I say about this? Let's see what we got here. Okay, 2 years ago, we had a requester for copies of all violation letters and then never paid for them or picked them up. This year, they made a request for violations for 2023, but we've denied due to non-payment. They then promised to pay for the copies for both years, but again, they never picked up or paid for the copies. Can that be considered a disruptive or problem requester? And can we deny all future requests? Okay, multiple answer here. Number one, a disruptive requester, uh, that is a specific term under the right to know law with a specific meaning. The answer is no. This would not constitute a disruptive request. However, the second part of your question, can we deny all future requests? That goes back to what I was talking about, and my answer is hopefully yes. Okay. It's going to be specific to your situation. And it's going to depend on whether you've dotted all your I's and crossed all your T's. My gut feeling is yes, you have the opportunity here to deny the second request based on non-payment of the initial request. But again, I can't give you a definitive yes because there's always something that could impact this that I'm not aware of. But I would maybe have a conversation with your solicitor. If you want to call our office to go over the specifics, we can't, again, we won't give you a definitive answer, but we can kind of explain the situation as to how we review it. And then you can make a decision as to whether you want to go ahead with denial. But I think, just at face value, given the information you've given me, you want to take a closer look at this. Okay, another big one here. Let's take a look. I have to scroll back up. It's off the screen. Oh my gosh. You know what? I'm going to have to come back to this one, but I will. Okay, let's move on. And then I'll come back to these longer questions. Come over here to the other screen. Okay. Certified records. We are close to the end of the presentation here, so it's not going to take me long to come back to these questions. Under Section 1307C of the Right to Know law, there's a section, a reference about certified records. What is this? Okay. It allows you to charge $5 to certify public records in response to a right to know request. This will come up periodically when someone is dealing with a court case and they need these records to present as part of the evidentiary trail or their, I shouldn't say evidentiary trail, just part of the documentation for whatever litigation they're involved in. So they submit a right to know request and they request certified copies. Okay. So the agency will provide a statement and you can find sample language of the statement in the Arrow Guidebook, which is available off the OOR's website, 78 pages, lots of useful information in there, including this. Um, but essentially, the agency is only certifying the accuracy of the copies. They're basically saying these copies are true and correct facsimiles of the originals, and that's it. You're not in any way certifying the provenance, like an evidence trail in law enforcement. Okay, you're not saying that what is on the record is accurate and true. You're only saying the copy of the record is accurate and true. Okay, so that's what it means when someone is requesting certified records. Okay, and that's how you go about doing that. And then you can charge $5 for each certification. Okay, transcripts. This comes up probably once or twice a year, so I think I better cover it here. It's interesting, I get questions about this during webinars. Section 707C. This primarily involves adversarial hearings, usually related to like zoning issues or building permits and the like, where there is an actual hearing that takes place. It's not a public meeting, it's a hearing. Okay. And sorry, someone will submit a right to know request for a copy of the transcript of that hearing. Okay, now under the right to know law, there are two conditions that need to be met in order for the transcript to be provided as if it were a public record. Okay, the first is that all appeals must be exhausted, okay, through that adversarial process. So you could have like a zoning hearing board, and then it could go to the elected officials, and then litigation could take it even further to the county court, to the Commonwealth Court, all the way up to the Pennsylvania Supreme Court. So all of those appeals have to have been exhausted, meaning that either the person didn't bother to appeal or the courts have decided and there's no other appeal steps. Okay, that's the first one. And then the second is that the agency must actually have a copy of the transcript. And you're saying, well, why wouldn't they have a copy? Well, you need to know how the system works. Many of these boards will hire an outside stenographer who does this professionally, and they pay two fees. The first is the stenographic fee, which in order for you to come in and actually take the stenographic notes, we're going to pay you X number of dollars. And then the second fee is for the actual transcript. And the agency will usually only request the transcript if they need it for further appeal purposes. Otherwise, if they need it in the future, they can rely on the stenographer to keep a record in his or her files. Okay, so you may have instances where a transcript was generated, but the agency doesn't have it. So if the requester wants it, the agency is not required to get it because they don't have it in their possession. But their response could be, you need to go to the stenographer firm and then pay whatever they charge, which is usually far beyond what you would pay for a right to know document. Okay, it's well more than 25 cents a page. It's usually a couple bucks a page. Now, if the agency did request a copy and they have it in their possession and it's determined to be a public record, they can provide it as if it were a right to know document. Occasionally, the stenographer will say, no, wait a minute. That person has to pay me because I'm the stenographer. Well, no. The right to know law says if the agency has it in its possession and all appeals have been exhausted, it's a public record. And thus, the OOR fee schedule applies. Okay. The stenographer's not happy, but that's what the law says. So they have to grin and bear it. Okay. So that's how all that works. Okay. Additional resources. This is the final slide. Take a look at this while I read through this other question here that I'm going to come back to. Okay. Our township has increasingly been inundated with voluminous right-to-know requests where people, usually lawyers, oh, those darn lawyers, who want everything, ask for all communications within the township on top of all records for specific items. Since all our records are electronic, we cannot charge a fee. This requires all employees in our ID department to scrub their emails, texts, voicemails sent to the right-to-know officer, who then has to read and listen to hundreds of communication chains and spend much time with our solicitor to determine redaction and withheld items. Not only does this take time away from all employees, it becomes almost impossible for the right-to-know officer to juggle their regular job with all of these requests. Could right-to-know officers somehow lobby together in order to change the law to add some sort of constriction for these huge requests? Well, to your immediate question, can everybody lobby together? Well, yeah. And, there was a change to the Sunshine Act, the open meetings law a couple years back, because the public complained about the fact that agencies, municipalities were not providing agendas. So they amended the Sunshine Act in response to public outcry so that now there is an agenda requirement. So if you believe that a change needs to be made to the right-to-know law, there are a number of things that you can do. You can reach out to your legislator. You can reach out to the state government committees in the House of Reps and the state Senate. You can reach out to your advocacy agencies, the Pennsylvania State Township Supervisors Association, the Pennsylvania State Association of Boroughs, the Municipal League, all those that apply, and request that they contact the legislature on your behalf. Yes, to answer your question, you can lobby. The Office of Open Records is not an advocacy agency, okay? We are an independent tribunal, and it's not our role to advocate on behalf. But periodically, we are contacted by legislators saying, hey, I'm considering introducing a bill to update the right-to-know law. What are your observations? And we will communicate concerns that we hear from people. And what you're talking about, I think, is where attorneys are conducting what we call pre-discovery. When litigation is filed, the courts determine this term called discovery, which is the exchange of records between the parties who are suing each other. Okay. And sometimes attorneys, before they file the actual litigation, or even if they do, they will use the right-to-know law as a means for procuring as many records as they can, because the right-to-know law is usually much broader than discovery. If the litigation has already been filed, one of the things that your solicitor can do is approach the judge and say, look, we've got an attorney here who's using the right-to-know law for discovery. Is it possible to get an injunction? You might want to consider that. I'm not, we just don't hear about that all that much here. So I can't tell you whether that would be successful or not, but that's what's going on. The other thing is to take a look at the actual records that are being requested and making a determination. Are these in fact public records? Maybe they should be withheld. The other thing is the question of specificity. Okay, and again, you want to talk to your solicitor about that. Specificity is a specific term referenced in the right-to-know law, where it basically says the record or the request shall be specific enough that the open records officer is able to determine what is actually being requested. Sometimes a request is so broad that you cannot specifically identify a record. So that may be an issue. But I think what we're really talking about here is this practice of what's known as pre-discovery, and maybe talk to a judge about that. But as far as the lobbying goes, my answer to that is yes. And you have to take it from there, though. We do not here at the Office of Open Records lobby on your behalf. Okay. Good question. I'm sorry to hear that you're going through that. Yeah, hopefully you're welcome, and hopefully you can resolve it in a positive way. Okay, what is the status of the proposed legislation to allow agencies to charge for records that are used to solicit business? Renee, I have not heard anything new on that for a couple of years. I'm retired from the OOR, so I'm not here every day. I'm basically here as a consultant. Um, and I periodically meet with the deputy director, and he updates me on anything new, usually includes legislation, and I haven't heard of anything for a couple of years. So I don't think that there is anything active in the hopper this session of the legislature. Yeah, they pay me to talk. But again, reach out to your legislator, your advocacy agencies, and let them know about your concerns, okay? And if they know that this is a hot button issue, that it's become a problem once again for agencies, then go ahead and reach out. When I did the live training, okay, and we haven't done that since COVID, but what I used to emphasize is that when it comes to these commercial requesters, which is what you're talking about, um, again, take a look at the payment side, okay, because number one, are you required to provide the records that they're requesting? Are you required to provide the records in the format that they're asking for? Because a lot of these ask that you put information into a spreadsheet and you're not required to create a record. Okay. And then the other thing that you want to take a look at is, have these businesses ever filed an appeal in response to either a denial or a deemed denial, which is where the agency just ignores the request? Okay, now I'm not telling you to do that, okay, but I can tell you that in examples where an agency has ignored a request from a commercial requester, has that commercial requester turned around and filed an appeal? And the way to find that out, again, is to go to our database and search on that requester. Do they ever pop up? Or for that matter, you can call the office and ask them to search the database. Say, has this commercial requester ever filed an appeal? All right. And if they haven't, that kind of tells you something and how you might want to deal with some of these commercial requesters. All right. Now, that's about all I can say ethically, because you're a smart person and you can kind of connect the dots as to how to proceed. But if you're wrestling with these commercial requests, maybe you want to take a look at that, okay? Because again, the legislation isn't there yet, okay? And it's been bounced around for as long as the right to know law has been out there, because they did not anticipate commercial requesters. All right, but we haven't seen anything make it into law. So maybe you want to take a look at whether or not they've ever filed an appeal, okay? And that will kind of give you some insight as to how you might want to proceed. Okay, we are at the end of the presentation. The slide up on the screen gives you a wealth of resources that you might want to take a look at related to the right to know law. You know what I'm about to say. This is the best government website that you will ever encounter. It's updated 6 days a week with new information, new case law, new final determinations that are issued, new training opportunities. Take a look lately at the blog that the executive director runs, because there's been a series on the exemptions within the right to know law that is very helpful. If you've sat through the basics course and you hear me talk about the exemptions, I just do it in general terms. If you want to specifically know like what each exemption means and how is it regarded relative to current case law? Maybe you even want to tell your solicitor about it because it's good stuff. And I would recommend taking a look at that. I already mentioned the Open Records Officer Guidebook. It's really cool out there and very helpful. And if you are a true geek about government transparency, subscribe to our Twitter feed. And every morning at like between 7 and 8 a.m., we will wake you up with a tweet of all the day's business related to government transparency. Okay, everything you would ever want to know and then some. But again, if you have any questions, reach out to our office. Now, look, we can't write requests for you. We can't respond to requests on your behalf. We can't, write your responses for you. We can't we can't discuss any active appeals, but we can steer you in the right direction when it comes to similar cases. All right. So reach out to our office if you have a problem, and we'll try and help you as best we can. But I'd like to thank you today for your participation. We've had a couple good questions, some issues that I haven't seen for a couple years, so I appreciate that. And thank you for putting up with my voice this morning. Hopefully this will be going away in a couple days. I don't know. But stay warm out there, and we'll see you more than likely in 2 weeks with our next webinar. Take care, folks, and we're signing off.